On 1/1/24, Taylor officers were dispatched to 7-5 for a male stating he was struck by a vehicle. Upon arrival, officers were met with Cody Welch, who stated the following. He lives at 7-5. He went to the bar with his neighbor, Bradley Welch. The pair returned to 9-5 at approximately midnight. Once at the home, the pair got into an argument with Bradley Welch's girlfriend, Amy Cochran, outside of the home. Cody Welch then, standing in the westmost lane of South during the argument. Cochran then got into her vehicle and began backing the vehicle out of the driveway, striking her own car. Cochran then continued to back the vehicle out onto. Cochran then placed the vehicle into drive and began accelerating at a high rate of speed towards Cody Welch. Cochran then struck Cody, throwing him to the side and onto the curb. Cochran then continued southbound away from the scene. Officers then received information that Cochran was at her mother's home at 1-2 Southgate. Went to location and observed Cochran's vehicle in the driveway. Area towing was called to retrieve the vehicle, and upon area arriving, Cochran came out of the home and began arguing with officers. Officers advised Cochran that she was under arrest, placed her hands behind her back. Officer Duford then grabbed Cochran's arm and placed her into handcuffs. Cochran then pulled away from Officer Duford and began taking her shirt and jacket off in an attempt to evade his grasp. Officer Duford then took Cochran to the ground, and multiple officers assisted placing her into handcuffs. And she was then transported to Taylor Police Department.
All right, let the record indicate that I find probable cause to believe the accused committed the alleged offense and will therefore issue the warrant. So we're all set, and I think they're going to bring her on in just a few moments on arraigning her. Do you have any position as to bond?
Just that they are neighbors, so obviously like a no contact with the two, but besides that, leave it up to you, ma'am.
Okay.
Will you hand me my spin box?
Zarica, I'm sorry, versus Brianna Kingsley.
Good morning, Your Honor, or afternoon, Your Honor. Attorney Andrew Batnick on behalf of the plaintiff.
Brianna Kingsley? Oh, there you are.
Good morning, Your Honor.
Good afternoon.
Oh, no, nice.
It's okay. The last hearing I had a total amount of $35.73 owing. Is that where we are still?
Your Honor, we found an additional $490 when there was a request for a ledger for monies owed. It seems that Ms. Kingsley had always paid digitally. She had paid my client directly through, I think this is probably Cash App. She asked for a refund and they processed a refund of $490. So an additional $490 is owed on that prior amount.
Okay, so what's the total amount you're claiming?
So it is $3,430 in rent, $450 in late fees, $183 in court costs, which is a total of $4,063.
And do I have a response to that?
My response is the accounting that I received from the landlord does I have not received a refund of $490 that they claim. I checked my accounts. It has not come to me. Additionally, the accounting was not complete. They showed my payment history, and I am the co-lessee with A. Begovich. There is no payment history from my former roommate.
Well, usually the payment history is by unit.
And that's not what I received, sir. May I share with you what I received from them?
Let me see it.
Yes, sir.
And Your Honor, so the court is aware at the last hearing, the defendant told the court he had not paid, or she had not paid October, November, and December's rent. That's already on the record.
I don't understand the $490 chargeback.
So I'm not sure what the court may be looking at, but if it was my cover letter from December 15th, it included the attachments. There is, what the court will see in the attachments, the last 2 pages, you will see the verification that the 490 was initially received, and then a second verification that 490 is being refunded through the Cash App. It was requested by the defendant and has been pulled back from my client's account. I would ask the court, or I can inquire of the defendant, if she did request a refund. I know she says she didn't receive it, but she didn't state whether she requested one through the app.
Did you request a refund?
I did talk to my bank about some fraudulent activity on my account, and this was one of my concerns because I've communicated exclusively through Mr. Carrick. Mr. Milovan goes by Mitch, but all the paperwork's from Zorica, so I was not certain who the actual owner was. As I said, I have not received the refund, and I can show that if that's helpful.
No, not at this point. I mean, the absence of something isn't going to necessarily help me. All right. So you did, I recall at the last hearing, indicate that you did owe those other months.
At the last hearing, I indicated that I have stopped paying because they have failed to maintain a safe unit.
All right, here's what I'm going to do. Go ahead.
Yes, sir. Thank you. I have a copy of an inspection report from Ypsilanti Building Inspection Officer, Ms. Jamaica Berry. When they first attempted to accuse me of destroying the property, I thought it would be helpful to get a third-party inspection by the city. Ms. Berry found 12 violations on the landlord's behalf, did not find that I had caused any damage. I have that full report to submit into evidence.
All right. Well,
And I have,
hang on. I'm not going to take evidence at this point. It looks like first thing that I'm going to need is a written answer from you as to this complaint.
okay,
So I need a written answer by 1 week out. Can you do that?
1 week out with the holidays, can we make it first of the year?
All right. Written answer by January 2nd,
Thank you.
2024. I will adjourn this matter then out to January 5th, 2024 at 2 p.m. And then we'll see where we are. With that written answer, you have to file a copy with the court and you have to send a copy to council.
Does it have to be officially heard or just to the council contact?
To council, you can send it via email to him or however you need to get that communicated.
Thank you for your attention today, Your Honor.
Thank you.
Your Honor, any escrow order for the rents being paid, or are we holding off here? Because my guy is still not receiving rent, unfortunately.
Let me see. Well, this was set December 15th. We're at the 22nd. Under the new court rule, I can't order escrow at this point. It has to be 14 days.
Okay, so we'll have to deal with that on the 5th.
Yes.
If I may, sir,
Your Honor, last question. I'm still traveling on the 5th. I could resubmit another request, but I didn't know if a request to have myself heard.
Yes. You can submit another request.
Okay, thank you, Your Honor.
Thank you. And yes, ma'am, you had another.
I did, and then it just lost me. I have receipts for the repairs that I've made to the unit in regards to escrow. I heard that I don't have to start the escrow now. My attempt so far, what I've done, I've already worked with Mishta, but because the landlord had previously failed to give me an accounting date, I paid.
Ma'am,
report on that.
You'll need to supply that in your answer.
Yeah.
And then I can take whatever need to into account regarding escrow. Okay, thank you.
Happy holidays.
Lakestone Apartments. All right, let me get one more here. What did she say? it's Sarika or Zarika Carrick versus Brianna Kingsley.
Good afternoon, Your Honor. Attorney Andrew Babnick on behalf of the plaintiff.
Hey, Judge, good afternoon. Brianna Kingsley, attorney.
Happy New Year. All right. I think the last time I was here, I was supposed to get a written answer. Did you get that filed?
I have, that available. I went to the to have them review what I prepared for you. They weren't able to get me in. So this is what I have available today for the written statement.
No.
I have the executive summary in one page
Executive summary of what?
of the circumstance. You asked for a written statement. I have one.
No. Okay. What I asked for you to file is a written answer. That's under the court rule. I need to have a written answer to the complaint in a format that the court rule provides, which means you have to answer the complaint paragraph by paragraph. And you have to lay that out and attach whatever exhibits you are to it. A copy of that answer then has to be provided to plaintiff's counsel.
Thank you for educating me on the process.
Okay.
As I said, I have this prepared. I was going to have it reviewed by Miss Tanya over at Legal Aid downtown Ipsy. I saw her on Wednesday. She told me to come back on Thursday. I came back on Thursday and they were too busy to take me in. This is what I have, sir.
Okay. All right. I'm sure over the holidays they were busy.
Your Honor, as a reminder,
Counsel,
I know the court's hands are tied here. This is the third hearing on this file. I've got rent, late fees, and court costs up to $5,300 at this stage. And as the court may remember, there was originally a file filed by my client, improper, that I had dismissed and refiled to make sure notice was proper. So this has been dragging on for some period of time.
no, I know. I hear you.
Right.
Here's what I'm going to do. I'm going to adjourn this out 2 weeks. You need to get that corrected. It has to be in proper form for the court. Counsel for the plaintiff needs a copy of whatever you file with the court.
Before the next appearance.
Well, I want it filed by the 12th. I want it filed within a week. I'm going to adjourn this out 2 weeks because counsel for the plaintiff is going to have an opportunity to look at it, and I'm going to need an opportunity to look at whatever you're filing.
Yes, Your Honor.
I am not going to take any excuses if it's not here. If it's not here, I'm going to presume there is no answer and I'm going to issue a default. Because I've given you this is the second time I've given you to go around outside of what happened in the last case. You follow me?
I apparently I didn't. My impression was that I was to show up with a written answer and that's what I've done.
No, I have your written answer.
Sorry,
Your written answer was due by January 2nd.
where is that listed, sir?
It's right in my file. I wrote the note. I do it all the time.
May I have someone point that out to me? I'm supposed to say the third. Does it appear on me?
Those are my handwritten notes right on the ROA. Written answer, January 2nd, 2024.
May I have a copy of that, sir?
You can get a copy at the clerk's office. I'm not providing you a copy of anything. I ordered it on the record and that's when it was supposed to be here. Even if you believe that it was today, that's not an answer and plaintiff's counsel doesn't have it. So I'm making it very specific. You will provide a written answer in conformity with the Michigan court rules. You will do that no later than close of business on January 12th, 2024.
Yes, sir, I will.
Your Honor, is the court able to order escrows at this time? It's continuing to be due.
I can order escrow. What is the monthly rent?
$980, Your Honor.
It's disputed, Your Honor.
Okay, but I'm going to order escrow in that amount. Can you prorate that on a 30-day for me? Yeah.
But sir, they failed to provide safe housing. He locked me out.
Okay, but listen. Huh? 980.
980. Okay.
Well, hold on. 980. What's my pro rate for January?
Well, it's $33 a day.
Okay.
I mean, Your Honor,
Say what? Escrow is ordered in the amount of $858. That's the prorated amount for January. And then in the amount of $980 thereafter. That must be paid 7 days within the date that rent is ordinarily due. Plaintiff's counsel will prepare an escrow order for signing by the court. To that effect, yes.
the ledger, the schedule provided by the plaintiff is not GAAP compliant. It does not show the total amount paid per month by who. It is an insufficient form, and I have all that here. I have a response, sir, that I think is relevant to whether the escrow starts now or in the future, because
Ma'am?
I have copy, for example, if I just make sure this part, the Ypsilanti building inspector came and found 12 violations against them, not against me.
The escrow needs to be paid. I will take that into consideration in terms of any counterclaim or other thing that you're filing. But in terms of the escrow, that's what I'm ordering it.
Okay, so Ms. Mills, my caseworker at MISTA, said that I applied for state emergency relief help for the eviction when it originally started back in October, and was told that the landlord must provide a statement. The statement that they provided to the court wouldn't pass any accounting 101 course, sir. It does not show the proper.
For what? They needed to provide a statement for what?
May I hear your question again, Your Honor?
They needed to provide a statement for what? What was the purpose of the statement?
About how much rent is owed, the amount that they're claiming, the fact that they broke the lease, like their response that they sent has a schedule on it, sir. And I think the court would find it insufficient. I cannot defend myself against vague allegations and incorrect math.
The math ultimately becomes incorrect. That will be straightened out. But right now, I'm ordering escrow in the amount of $980 per month, prorated amount for January in the amount of $858. When you go speak with legal services, certainly they can tell you how to ask this court to reconsider that order. But that's what I'm ordering at this point.
Understood.
Your Honor, the 858, would you like to do within 7 days of the order?
Pardon?
You would
Yes,
like
payment within 7 days of the order.
What happens when I'm unable to pay because I'm indigent and disabled and fixed income? I cannot pay $980. I never did. I paid half of that with a roommate they allowed to break the lease. What?
Okay.
I have everything here, but you don't want to see it.
Sir, ma'am, that's not what I'm saying. I need it in the form. Oh, you're going to turn your back on me.
Yes, sir, because you disrespected me right now, and I'm vulnerable in the court system.
That's just what I'd expect you to say. Dumb people are always blissfully unaware of how dumb they really are.
All right. Ma'am, first of all, so that the record is clear, I have not disrespected you in
Justice. I hear you say the things that you said was, I'm ready when you are.
Warning, Karen mode activated.
Ma'am, it doesn't feel good, does it, sir?
Ma'am, don't try to play that with me. I deal with that with students all of the time. I sometimes will make a mistake, but you are not going to have me feel guilty because of that. So if you wish, if you want to make that an issue, then you make that an issue. That is not my true thoughts. Answer by January 12th, 2024, close of business as indicated on the record. We'll see everybody January 19th.
What was the time?
2020. Pardon?
I didn't hear the time for the 19th, Your Honor. You may have been.
January 19th at 10 a.m.
Thank you, Your Honor.
Thank you, folks.
So how about what you ordered? Now,
What do you want a copy of?
what you just ordered, what wasn't clear last time. I left here thinking that I'm supposed to come up with a written statement, which I've done and you've denied without looking at, right? I just want to know what I'm supposed to do because it is not clear.
You have to file an answer.
And when you say answer, it needs to be a specific form. What form number, sir?
You have to go and find those. There, you can go to the Supreme Court website. There's a general form of an answer, but I have to have the answer filed in compliance with the Michigan court rules. All right, that's the first thing, and I need that by the 12th. You told me that you're in contact with legal services, correct?
I met with them once and
Okay.
this week, yes, sir. That's
Right. So what you need to do, and what I had indicated, is get back to them. They'll be able to assist you to make sure that it's in the proper form. All right. Have attachments to all of those and file that with the court, as well as send that to plaintiff's counsel. All right.
Yes, sir. Your Honor.
And then the other thing is, I've ordered escrow. Counsel for the plaintiff is going to be preparing that so that that order will be there. You will get a copy of that order.
Yes, sir.
And that's basically it. And then,
May I have that in writing before I leave? How do I get that in writing? I have memory issues. I'm disabled and I've already made the court aware of this. I need it in writing.
counsel for the plaintiff, will you please prepare an order submitted under the 7-day rule to the court, please?
Yes, Your Honor.
For everything that I ordered. That way there will be written communication.
Yes, Your
I'm
Honor.
done. Thank you.
Not a problem, Your Honor.
Court calls the case of the,
Good day, madam.
I will, thank you.
You're welcome. You look real cute.
As do you. Folks, I realize it, but give me 5 minutes, please. Court stands in recess.
All right. Ms. Hanson, come up to the door.
Thank you. All right, this is 23-1793 and 23-1518, the People versus Jessica Hanson. Ma'am, can you tell me your name? Jessica Hanson. All right, Ms. Hanson, an attorney attempted to speak with you, a court-appointed attorney. It's my understanding you didn't want to speak with him. Is that accurate?
Yes, ma'am, because I believe the last time I seen Judge Sutherland, or it was the guy, I forget his name. He told me to do a mental health class, which I was already in the process of doing. And he said, once I completed that, to call the county clerk, let her know what program I completed, which I did. It was New Oakland Health and Human Services with Rehabilitation Center.
Ma'am, Miss Hanson, Miss Hanson, you have a few cases here. You have a case that you were sent for a pre-sentence investigation and you never showed up and a warrant was issued. It looks like you took a plea and they reduced a felony to a misdemeanor and you were to show up at probation and you failed to do so. And that case is in warrant status. You have another case that's in warrant status for a larceny that allegedly occurred at Walmart on August 6th of 2023. So those are the two things you're here for. Sir, ma'am, I'm sorry. Are you waiving your right to speak to a lawyer?
I was in the hospital then.
Ma'am, listen to my question and answer. No, listen. We could take 45 minutes doing this, or we could take just a minute. It's up to you. I got nothing else to do. Do you want to talk to a lawyer?
No, because I thought this was a misunderstanding.
I'm telling you, it's not. There's a new charge that you didn't show up for that's in warrant status and an old charge.
And I didn't know I had probation. I got nothing from you guys in the mail.
Okay.
I guess
All
I'll
right,
talk
so
to her, 'cause I
on
did not-
this,
I
ma'am,
was in a hospital, in a mental health hospital at that. Like Judge Salamone told me to do. He said, go to a mental health.
you've not had Judge Salmoni. It looks like you've previously had Judge Slavin
That's
on
it.
your cases.
Sorry.
So,
He told me to finish the course, and I did. I called the
Okay.
counselor, and I did.
all right, well, ma'am, I don't have any record of that. All I have is that you absconded, you never appeared for your probation visit, and you've got another case for larceny that's in the system. Ma'am,
If I would've got
you've been
anything-
brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You have the right to a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you cannot afford to pay for your own lawyer. If you're looking at minimum jail time, or if you might get jail time, you might have to repay that if you had an ability to pay. If you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You also have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have a right to be innocent, presumed innocent until proven guilty beyond a reasonable doubt. If you plead guilty and or no contest and your plea is accepted, you would be giving up those trial rights. You have a right to be released on bond. If you are on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by a judge or jury, it may result in a violation of your probation. You could be sentenced to jail and fines plus cost, and the court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and a maximum possible penalty. Fines, costs, and other financial obligations imposed by the court are due at the time of assessment, except when the court allows otherwise for good cause shown. If you're unable to pay due to financial hardship, contact the court and request a payment alternative. Do you understand that?
Yes, I do.
Okay. So count one, or the first case ending in 1793. Is larceny.
A pair of shoes.
And the allegation is that you, on August 6th of 2023, you committed a larceny of over $1,000 at the Walmart. Looks like it's signed as a city case, so this is a misdemeanor punishable by up to 90 days in jail, $500, or 3 times the value of the property. Do you understand all that?
Yes, I do, ma'am.
Okay. So how do you plead to that offense for purposes of arraignment?
I plead, guilty.
You want me to enter a guilty plea before you talk to an attorney?
Yes,
Before you
because
come to court?
I'm gonna go to court, yes, but what I'm saying is, I was in my bipolar took over and I'm manic depressive. So right before I went in to my hospital, like he asked me to, I freaked out and
Okay, I don't want you to tell me any more, Ms. Hanson. I want you to wait for a court date on that. I'm gonna enter a not guilty plea. You could talk to an attorney, which I strongly recommend you do when you come in for your pretrial. And then the other one is a show cause or a warrant that was issued because you failed to appear on August 7th of 2023. The original charge was assaulting resisting police officers, malicious destruction of a building, and domestic violence. That was ruled down to an attempted resisting and obstructing an officer, and you failed to appear. A warrant was issued for your arrest. Interim bond was issued. So we're gonna reset this. It looks like you need to see the probation department and you need to come in for a hearing.
Ma'am, may I ask a question? How can I be in trouble for all of this when I was in the hospital and I got no paperwork?
Well, that sounds like a defense that you can bring up at the appropriate time, ma'am. But that's not, today, I have to tell you what the charges against you are. I have to explain all of this to you or I wouldn't be doing my job. Who do you live with?
I live with Samuel Serrata at 7815 Party Road.
Who lives there with you?
Samuel Serrata.
Okay. These are misdemeanor offenses.
I don't really get in trouble. I try to fix it. I don't know what happened.
On the case ending in 1518, where she failed to show up for the probation visit, she has a $2,500 personal bond. And on the larceny case, the 231793, she has a $100 personal bond. So altogether, it's $2,600 personal. Ma'am, you're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Do you understand me?
Yes, Your Honor, I understand all of that.
No alcohol or drugs.
Yes, ma'am. I don't
And
drink.
I'm assuming you're printed, but you have personal bond. You'll get a court date in the note in the mail. And if you don't show up for that court date, you won't get a personal bond next time you get picked up and you'll just sit in Wayne County. So make sure you show up for court, ma'am.
I will be there. I will be.
All right, you're all set for the day.
Thank you.
All right, we're ready when you are.
All right, Ms. Cochran, Your Honor.
All right, this is the people versus Amy Catherine Cochran, 240005.
Good afternoon, Your Honor. Judge Tenant on behalf of Ms. Cochran. We, for limited purposes of arraignment, we waive formal readings and use.
Okay, I'm gonna enter a not guilty plea on your client's behalf. And, ma'am, anything you say orally or in writing can and will be used against you in a court of law. You have a right to have an attorney present during any future questioning or any future court hearings. Do you understand all of that, ma'am?
I do.
Mr. Fanto is appointed to represent you today, and you will have an attorney, a felony attorney appointed for future proceedings. Ma'am, you have 2 dates within the next 21 days. The first is your probable cause conference. Your probable cause conference will be on January 17th of 2024, and you can appear at that hearing via Zoom. Your next hearing will be your preliminary examination. And that will be on January 22nd, 2024. At that hearing, the prosecutor will have to show that a crime was committed and probable cause exists to charge you with that crime. That is an in-person hearing. Do you understand that?
Yes, I can't write this stuff down, but I'm guessing I'll get something in writing that shows that later.
Oh, I'm sorry, what was that?
I'll get something that shows that in writing later. I can't write anything down right now, but maybe notes. I'll get this.
Yeah, you can have a copy of your advice of rights form and your bond conditions.
Okay.
Okay, and you'll get a notice of those court dates in the mail.
I'm gonna have my mail forwarded. Is that okay? Because I'm not.
Yeah, well, if you're not going back to that address, ma'am,
Well,
you
I just
are
want
going.
to belongings. I was advised that I should probably not be there because it's involving the neighbor.
Yeah, you probably shouldn't. I mean,
I provide the court with a different address.
Okay, we have all right, we have a different address and we'll make sure that your mail goes to that address. Mr. Fanto, is that the Edison address?
Yes, ma'am.
Okay, I'll
No,
make sure that.
thank you.
No, all right, ma'am, just listen. I've entered a not guilty plea on your behalf. These are serious allegations that have been made against you. At this point, they're just allegations, but they are concerning. I don't see Mr. Fantalista bond.
No holds, Judge. It appears that she said two matters that she apparently has completed successfully. She is a nurse. She's employed at Cornwall Health in Trenton, has been for 3 years. I appreciate the nature of the charges. It involves a next door neighbor, and again, while I appreciate the nature of the charges, Judge, she's not going to be in that location. I've explained the no contact provisions, and I would ask the court to still consider a personal bond in this nature, given her employment and her history of showing up.
I've worked at that location since 16, just not as a nurse. I've had the job since 2016. But it was
Okay.
different positions. But I worked there since 16.
All right, look. Ma'am, I'm going to give you a $50,000 personal bond. Okay, so you're not going to have to post anything. You don't have an excessive criminal history. But these are very serious charges. I want to be clear to you. You are to have no contact with Cody Welsh. None. If you see this individual, you run the other way. Do you understand me?
I understand.
If you see this person at a restaurant, you turn around and you walk out. You get up and leave. If you don't talk about this person on your social media, you don't text them, you don't email them, you don't have any contact, and you don't have anyone else contact them either. Do you understand?
I do.
Judge, you will need an officer assist. They're next door neighbors, but she
my mom could just go and get some stuff, and I wouldn't have to go, but I'm assuming that the neighbor in question is at work still until at least 5 o'clock, so I can just wait till during the day when he's at work, but I'm not allowed to talk to him to verify that. He does work days.
All right, well, I don't know how quick you're gonna get out. I know you don't have any holds, but you think a police assist is necessary?
I think so, Judge,
Okay.
only because just to avoid any potential confrontation.
All right, so you're gonna go to your house and get your stuff out, and you can ask the police for an assist, and they'll go with you. I mean, they're not gonna sit by.
My mom's gonna pick me up anyways. I don't have to go there right now and do it right now. I can just go to my mom's house tonight and call, and don't have to do anything.
I mean, I don't know who else lives in that house with you. I don't know if you're on good terms with them. If that's someone your mom can work it out with, that's great. But if you go near there and there's an allegation that you put your foot on someone else's property, then you're going to sit in Wayne County Jail. So that's for you to decide. If they can do it without you going there and your mom can grab what you need, that's fine. Otherwise, you can ask the officers. They don't have to do it today, whatever day you need to go. And they can.
I haven't seen my kids in a couple of days, and my mom has to watch the baby alone at night. It's been 3 nights. So I'm just worried about the baby and my children.
Okay, well, you'll get home. You'll be with the kids. I'm assuming that's the house you're going to, right?
My mother's house, that's what they're supposed to do.
All right, whenever you need to go get property out of the house, if your mom can talk to your significant other or whoever lives in that house with you and they can work it out, that's fine. If you go over there, you need an officer with you.
I understand. I don't want to.
Your court is directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You can't possess or have access to firearms, and you can't purchase or consume alcohol or illegal drugs. Do you understand me?
I do.
If you have, I believe this is a sign to me. You cannot have a single violation of the terms of your bond. Because I'm giving you a personal bond on a case where I generally wouldn't do that, but you have very limited criminal history. So if you violate it, you're sitting in county.
I know, I feel out here, I said, I won't.
Okay.
Thank you, Officer Dixon.
All right.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People going to learn how to act in the courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No, I know.
Okay.
I have no patience for that. But trust me, out of the day, I'm sitting up here, I'm the one that needs the drink.